Good afternoon to our distinguished key resource person, Professor Dr. Vijay Kumar Singh sir, Dean UPES School of Law, Dehradun, Dr. Payal Thore Madam, Head of the Department, Postgraduate Teaching Department of Law, Rashtrasanta Tukadoji Maharaj, Nagpur University, my dear colleague teachers and all participants. Postgraduate Teaching Department of Law, Rashtrasanta Tukadoji Maharaj, Nagpur University is conducting a national webinar on one of the most trending and evolving topic that is in the corporate world, that is modern corporate insolvency regime in India, a overview. The failure of some business plans is integral to the process of the market economy. When business failures takes place, one among the best outcome for the society is to have a rapid negotiation or renegotiation between the financiers to finance the going person using a new arrangement of liabilities and with a new management team. If this cannot be done, then the another outcome for society is a rapid liquidation. When such arrangements can be put into place, the market process of creative destruction will work smoothly with greater competitive robustness and greater competition. So the Insolvency and Bankruptcy Code enacted in the year 2016 for resolution of strays of a company, a limited liability partnership, a proprietorship, or a partnership firm or an individual persons. The legal framework of insolvency and bankruptcy impacts a number of economic indicators such as credit growth, job preservations, employment creation, entrepreneurship, and in turn overall economic growth. It also causes behavioral changes in terms of affecting the willingness of investors, bank, companies, and entrepreneurs to take risks. India did not have any prior experience of a law for insolvency resolution that was proactive, incentive, and compliant, market-led, and time-bound. It can be said to be we have in some form and addressed by the modern comprehensive insolvency and bankruptcy law in the form of code. To enlighten us on this topic today, we are having with us Professor Dr. Vijay Kumar Singh, sir, Dean UPA School of Law, Dehradun. Thank you so for accepting our invitation. Over to you, Saurabh. Saurabh, are you there?
Ma'am. Yes, ma'am. Thank you, ma'am. Here are few general instructions for
Hi, are you able to hear me?
Participants.
Yes, you are audible, Saurabh.
Okay.
Here are few general instructions for all the participants. First, questions and answers session will be conducted at the end. And the second one is, I would like to request to all our participants to kindly post their questions in the chat box, and to get the recording of this webinar, please subscribe to our YouTube channel. Now, I would like to request Dr. Payal Thore ma'am, Head of the Postgraduate Teaching Department of Rashtrasanta Tukadoji Maharaj, Nagpur University, to deliver welcome address. Over to you, ma'am.
Thank you, Saurabh. Respected Dr. Vijay Kumar Singh, our prestigious alumni from our department, my dear colleagues from the department, and all my dear participants, a very warm welcome to all of you for this national webinar on modern corporate insolvency regime in India, a review. Personally, for this particular topic, I can say this, that I know nothing about this topic, and personally I am very much interested in knowing many things which Vijay sir is going to tell us today about this topic. So I am really looking forward to it, and I extend my warm welcome and gratitude and thanks to Professor Dr. Vijay Kumar Singh sir for accepting our invitation very graciously and giving consent for conducting this particular webinar. So I welcome you, Vijay. Thank you so much for accepting our invitation, and I'm looking forward for your lecture. Thank you. Thank you. Over to you, Saurabh.
Thank you, ma'am. I'm glad to introduce our eminent resource person and our dear alumni, Dr. Vijay Kumar Singh sir. Professor Dr. Vijay Kumar Singh is professor and dean at the School of Law with University of Petroleum and Energy Studies, Dehradun. Dr. Singh is an experienced professional having worked at the Indian Institute of Corporate Affairs, a think tank and capacity building institutes under Ministry of Corporate Affairs, Government of India as head, School of Corporate Law, and also with the Competition Regulator of India, the Competition Commission of India. Dr. Singh has also been associated with Hidayatullah National Law University, Raipur as a faculty in corporate laws and securities regulation. Dr. Singh is a doctorate in law with basic degree in science followed by degrees in laws with gold medals in his LLB and LLM examinations from Nagpur University. He has also completed his MBA in HR from IGNOU. He is certified trainer on managing disputes and difficulties conversation on the board by Center for Effective Dispute Resolution, a mediator by ICADR. Dr. Singh has authorized the book titled Corporate Power to Corporate Crimes, Understanding Corporate Criminal Liability in India. He is also the author of Legal Studies 1 and 2. Dr. Singh is an avid writer and has written a number of articles on different topics like sports law, money laundering, corporate governance, environmental law, CSR, competition, insolvency, comparative business law, IPR, business, and human rights, and international trade economic law. He is invited resource person for several training and capacity building programs nationally and internationally on various subjects and topics. Dr. Singh is life member of Indian Institute of Public Administration, the Indian Society of International Law, and the International Center for Alternative Dispute Resolution, Indian Law Institute, and Indian Council of Arbitration. He is also a fellow member of Indian Law Institute. Once again, I welcome you, sir. Please enlighten us over this topic. Over to you, sir.
Thank you, Sarah, for such an elaborate introduction. I think I can be introduced by just one line that he is our alumni. I believe that is one of the best and proud introductions to be of a person. And I am speaking in an event of my own alma mater, and it brings me my memories of classrooms when I used to be a contributory lecturer. I believe many of us, we started like that. So it is always a pleasure to come back to your roots and speak whatever you have learned of it. And Dr. Payal pointed out about her naiveness about this subject. I believe we are all naive as far as this subject is concerned, because this is a new subject and a lot is happening in this, a lot of transformation happening in this. So I believe what I will do today is we will go ahead with some basics. And as the questions pour in, and if there are advanced questions, I will be happy to address them as well. So in the format, you can use the chat box while I speak. So I am tracking the chat box while I speak. So probably I will be able to pick up the questions from there while I speak, and will be answering some of them during the course of the lecture. And as per the format, towards the end, I will also address any questions which you have. I would also extend my heartful thanks to Ms. Chobe, because I believe she was the coordinating point. And thank you, madam, for all the coordination. It is good to be here with you all. So today's topic, as you can see, it is modern corporate insolvency regime in India, a review. Why we are calling it modern corporate insolvency regime? Because corporate insolvency regime has already been in existence in the country. It is not a situation that for the first time you are looking at the corporate insolvency regime. If you have a look at the Companies Act, under the Companies Act, this regime already existed. What has transformed is that now from the Companies Act, it has moved to a new legislation, stand-alone legislation, and a robust legislation with some important characteristics of insolvency resolution. And which are those characteristics? At the base of these characteristics are two things. One, early resolution, that is, you quickly resolve the issues. And second is recovery rate. So one of the major challenges which is there in insolvency is basically the recovery amount. Because if once something is declared as insolvent, probably it starts losing its value. And it is very difficult to recover the amount or the money stuck in the insolvent enterprise, or you can say the defaulting enterprise. So objective of this whole in modern insolvency regime is to ensure that there is more and more recovery which can be there of the amount which is stuck up in the insolvent entity. So this is what is the overall objective and perspective. To begin with, I would also like to cite the basic reference on the basis of which today's lecture is based. So in case some of you who are joining late, or you are having an internet connectivity issue, or you want to refer the things later, this is an article which I recently wrote. It is January 2021 article in Business Law Review. An objective of this article was to familiarize my students on the modern corporate insolvency regime in India. And so if someone has to do a basic reading on corporate insolvency regime, I think I have attempted in a way that a person can get a brief understanding of it thoroughly. So for people, you can access this at SSRN as well as on the National Law School Business Law Review website. This article is available. With this, let me begin with the concept as to why question one should ask, that why we are so much concerned about insolvency regime, why you need an effective insolvency regime. Now, insolvency, as you hear the word, it comes at a phase when there is an exit required, or when something fails. So as soon as something fails, you require a mechanism legally to close it, and that is where insolvency steps in. Effective insolvency regime in India is very, very important from a perspective of ease of doing business. And you may have easy entry. You may have a lot of mechanism by which the companies can be formed, your businesses can start. But if you don't have a proper exit mechanism, it is also an anti-competitive element in the system if you don't have a proper insolvency regime. How so? Because if you don't provide a proper exit mechanism, people will fear to enter that particular domain or territory. So it is very important for us to understand that exit mechanism or a free exit mechanism is equally important as free entry mechanism. So from a competition angle as well, an effective insolvency regime is a very, very important element. From ease of doing business, it is an important element. Honorable Finance Minister, the late Arun Jaitley Saab, said that this is one of the biggest economic reforms, next only to GST. So one of the biggest reform which happened in the whole system was GST. And the second important economic reform which has happened is the insolvency regime in India. And I must tell you that I am a great admirer of this particular system of insolvency regime, and particularly under the leadership of Dr. MS Sahu, the way he has led this Insolvency Bankruptcy Board of India and the mechanism and processes. I believe it is a very, very robust system which has been developed, and a system to emulate. I believe it is one of the best regulators that have taken it forward in terms of research, in terms of the driving the regulations. All these dimensions have been done in a particular way. Insolvency regime also looks at a way of not only closure of the businesses, but also to revive and rehabilitate the businesses. So ultimate goal of insolvency regime is not to close the business, because closing the business will always give you losses, will always give you a situation wherein you are faced with the losses, you are faced with money crunches, you are faced with situations of employee leaving, or sacking of employees. All these things can be avoided if you are rehabilitating that enterprise. So it is not a situation that before IBC there was no rehabilitation mechanism. There was a rehabilitation mechanism, but all those rehabilitation mechanisms were not working successfully. Either it was Sikh Industrial Companies Act, or it was BIFR mechanism, or it was any other mechanism of rehabilitation and revival, because their root was rooted in a question. Because what has happened, there is a change which has happened under IBC regime, that is of control. In previous regime, the control used to be with the debtors themselves, whereas in insolvency regime, the present insolvency regime, the control is now shifting to creditors. And I will come to that in a while, and you will appreciate that in a detailed way. If you see, one of the important element of having a strong, or why you want to have a strong effective insolvency regime, is that you want to create financial stability. You want that there is an environment of investments. You want that there is a proper mitigation of corporate failures. All these dimensions are important. You also want to see that the financial resources of the country are utilized efficiently to enhance overall growth of the economy. As I was telling you about World Bank Ease of Doing Business ranking, and one of the major drivers of IBC was these rankings, because there are two important parameters other than the rest of the parameters, like starting of business, getting electricity, registering property. Two important parameters of enforcing contract and resolving insolvency. These are the two important parameters under EODB ranking which needs to be addressed. And as you can see, under resolving insolvency, time, cost, outcome, and recovery rate of commercial insolvency and strength of the legal framework of insolvency is the thing which is tested by EODB ranking. So time basically means that you should have a resolution in a proper time frame. Cost to resolve the commercial dispute, cost and outcome of the insolvency process is basically that how much cost you are involving in the whole insolvency process. And second is, what is the recovery rate? How much money you are recovering out of 1 rupee, say 30 paisa or maybe 50 paisa or 90 paisa, depends. And the strength of the system, that I am terming it as pillars. So there are pillars to IBC which actually drive the IPC or hold the IBC properly. So let us look at those pillars. So, but before looking at the pillar, what was the need for the code? Need for the code was being spelled out in number of committee reports. One of them being Rajan report. It said that the framework of bankruptcy resolution in India is fragmented, complex, fraught with problems. Later on, then the default, or if the debt gets default, it is very difficult to recover it. And you would recollect there is a legislation called SARFAESI, which came, the Debt Recovery Tribunal, DRT law came. All these legislations could not help the proper effective recovery mechanism or proper effective resolution of debt disputes. And that is why there was a necessity of having legislation like IBC. If you see, one of the major challenges under the prior to this particular code was destruction of asset value. If a company goes into the winding up process and it takes several years, as you can see here, the average time period for an insolvency proceedings under the Companies Act was about 8 years. In some cases, it has been told about 20-25 years. What happens to that particular company in that particular meanwhile? It is with the official liquidator. Nothing is happening in that company. The factories are taking rust. So probably there is having no value. This concept has completely changed under the Insolvency Bankruptcy Code. Now, under the Insolvency Bankruptcy Code, it is expected that the company has to be in a running enterprise till the time it is getting resolved. And it is not in the same person's hand who are responsible for insolvency, who are responsible for default of debt. So the control now shifts from the owners of the company to the creditors of the company if they default. So there is a big balance which has been now brought up under the equity holder and debt holder. So if the equity holder is not able to repay the debts and there is a default, equity holders lose control of the company and it goes into the hands of the debtors. So this is creditors. This is how the system of IBC work, and this has actually changed the scenario a lot. There were also a problem of plenty, which I call, and the problem of multiple fora. So previously, if you will see, there were plenty of forums available for any debt holder. So this is a classic case of BHEL versus Arunachalam Sugar Mills Limited. This was a case of debt by a bank, and you can see there were 6 different routes which creditors have taken, 6 different creditors. Someone went under SARFAESI, someone filed a civil suit, someone went for an arbitration, someone went for an unsecured creditor, went to the civil court. So you can see there are plenty of mechanisms. What is the outcome of this? Outcome of this is that even if one of them is decided, it is subject to the decision of the other. And there may be conflicting decisions. High Court giving different decision, DRT giving different decision, SARFAESI giving different decision. So this confusion led to many problems. And that is why there was a requirement of a system, which system helps the whole resolution at a go, and all processes are targeted towards one way. And that is what IBC does. In IBC, there is a moratorium period. So as soon as a matter reaches the National Company Law Tribunal, which is the adjudicating authority under IBC, the moment it is done, there is a moratorium period which applies. So no court would have a jurisdiction when the matter is under IBC. This actually saved a lot of this particular queries or a problem of reaching out to multiple forums for resolution of the same debt dispute. And this has helped a lot. Second thing which has helped is that the IBC provides for the timelines, provides for resolution of dispute within X days. And this is something which is unique. And though it is not being enforced very strictly, that I will come to when you see the reports of IBBI, latest reports of IBBI, that in a number of cases, the period has gone beyond the 180 days period, which is talked about under the IBC. So let us now look at the creditor's perspective I was talking about, right? So whenever there is a default, default of debt, payment of debt, if a creditor does, the account becomes NPA. You must be aware about this particular term, NPA, non-performing asset. So asset becomes non-performing when it remains unpaid or there is a default for 90 days, that there is a prudential guidelines by RBI under which it is governed. And previously, what used to happen is the debtors would have very less remedy. They would not have the remedy as available under IBC right now. So secured creditors or these particular people would go under the SICA, or if the company, say for example, files application under the Sikh Industrial Companies Act, under section 22 there will be a stay, and stay will be basically in the favor of the debtors, not the creditors. And the creditors will keep running after their debt. And there is a famous saying that in a SICA matter before BFIR, the creditors would come in auto rickshaw, and debtors against whom the complaints are, they will come in BMW. So this is what was the situation prior to IBC. But now things have changed. Now you completely lose the company. Once there is a default, you would not be able to run that particular company under the board, because everything is taken away from you and it is handed over to a professional, that is called insolvency professional. This is a unique addition under the IBC, wherein the professional managers take over your company if you are not able to run your company without incurring, without meeting the requirements of default. So this is a major change which has happened under the IBC, and I call it a creditor's perspective. So what is happening now? Now it is happening that the creditors will take control of the situations. This was one thing. Another important thing was before the IBC period was that all the creditors would independently chase their debts, and that would be a situation of a chaotic run kind of on assets. So everybody would try that, yes, I should get the things first. The other person would say that no, I should get my money first, and this would lead to multiple filing of cases, multiple issues, and that got taken care of here, because now under the IBC there is a requirement of bringing all these creditors together under the name of committee of creditors. So whenever there is a default, after that, the credit debtor loses the control of the company. It goes in the hand of the independent professional, and then thereafter there is a committee of creditors appointed, and these committee of creditors ultimately decide the fate of the company. This is what exactly happens under the new and modern corporate insolvency regime. So if you see, there are some principles behind the code. Why this particular code? What houses which kind of principles? If you see, there are these are the major objectives, and the IBC is guided by the Sectoral Legislative Guide on Insolvency 2005, and these are the major principles. That is provision of certainty in the market, maximization of value of assets, striking a balance between liquidation and reorganization. As I said before, the objective of all these proceedings is not liquidation. We don't want to kill the company. We want that the company should be reorganized and it should run. Killing a company or dissolving a company is the last option which is available. Ensure equitable treatment of similarly situated creditors. This we also call it as. So waterfall mechanism clearly tells that which creditor will be paid first. Secured creditors, government dues, who will rank when. And I believe this particular ranking helps every creditors. They know that how this thing will be treated, and everybody is at peace as far as the corporate insolvency resolution is concerned. Otherwise, previously there will be multiple litigations happening in different forums, and that would actually run down the value of the assets. So there won't be maximization of value of the assets. Provision of timely, efficient, and impartial resolution is there. Preservation of insolvency estate to allow equitable distribution of creditors is there. And there is also a new framework of cross-border insolvency. So insolvency will not only operate in the Indian borders, but even if there is an asset of an Indian company abroad, it will work in that particular way. Or maybe the asset of a foreign company which is operating in India and their asset in India may be taken care of. So I believe this is an extraterritorial applicability of the law which is brought up, though this is not enforced yet, but I believe it is at advanced stages of enforcement that it is going to happen. And I believe this is and very important provisions under the new code. If you look at the overall IBC is a big code, and its constitutionality has been held under the Swiss Ribbons case, Union of India 2019. Supreme Court has dealt with this case. I also have talked about this in my article, wherein I have brought up the fact that the Supreme Court has been kind enough, and even in fact, the all kinds of courts have been kind enough to take up these matters of IBC on priority and settle the jurisprudence fast. I believe after 2016, it is now only six odd years, and within this 6 years, a lot of jurisprudence has come up under IBC. A lot of transformation has happened, and this basically helps the legislation to grow faster. A lot of changes under the IBC Act itself, different regulations, and this is possible because of the active support of the government, active support of the regulator, active support of the judiciary. Everybody is tying around this to help the economy grow and let the system work. If you see here, the brief IBC is having basically 3 major parts. So part 3, part 3 deals with insolvency resolution of individuals and partnership firms, and this is the part which applies to the it is individual insolvency, which I call, or personal insolvency. This part is not yet enforced. Rest of the part, that is second part 2, talks about your corporate insolvency resolution process. There are 255 sections which are arranged into 5 parts. I'm not going into the detail. You can go and have a look at the legislation. It is pretty interesting legislation to look at. This is a unique legislation which has got 3 preliminaries and 3 definition provisions. So all these parts are starting with a definition. So there is a definition in part 2, there is a definition in part 3, and there is a definition in preliminary as well. So it is quite interesting fact to note. There are 2 adjudicating authorities under the law. So for part 2, that is corporate insolvency regime, National Company Law Tribunal is the adjudicating authority. And for the personal insolvency part, which is notified, Debt Recovery Tribunal would be the adjudicating authority. This is how you will find that the National Company Law Tribunal comes under the administrative regulation of Ministry of Corporate Affairs, whereas Debt Recovery Tribunal comes under Ministry of Finance. Quite interesting thing. 2 different ministries under the same legislation are the administrative ministry. It's quite unique legislation, and once the part starts, I believe every one of us would be affected by IBC. I'm not saying that we will be utilizing IBC, because unless you want to become bankrupt, you will not be utilizing IBC. But it applies to all defaults. So probably depends that how much is the default amount. But anybody can trigger IBC if that default amount reaches that default amount in case of individuals. Now, let me talk about some important elements, and I call 4 pillars. So I will be talking about these 4 pillars, and I think that much is the time today I have. So we will talk about these 4 pillars today, and then I will take questions. So 4 pillars under the IBC is basically the 4 pillars have been talked about in part 4, which talks about regulation of insolvency professionals, agencies, and information utilities. Now, when I talk about the first pillar, as I told you, is the insolvency professionals. Insolvency professionals and insolvency professional agencies and insolvency professional entities have been talked about, and this is a new mechanism under the Insolvency Bankruptcy Code. So one of the major challenges under the Companies Act liquidation proceeding, or you can say winding up proceeding, one of the major challenges was in relation to professional approach. So there was no professional approach. This is what the P.K. Vishwanathan committee report, which recommended for IBC, talks about. It says that there is across the world, whichever insolvency regime you look at, there are professionals who manage the insolvency or insolvent company or the company under liquidation, because you require different kind of a skill to manage them. You want to reassure the investors, you want to bring in the interim finance, you want to change the administration, you want to take strict steps, and want to make a non-profitable company or a loss-making company towards at least neutral. This is something which requires a lot of skill of finance, of management, of law. So this requires a different kind of a skill altogether, and that is the reason the regulators thought of that, yes, we should have a professional who would deal with this, and they called it insolvency professionals, IPs. These are called insolvency professionals. As you can see in this particular slide, latest data December 31st, 2021, there are about 3,950 insolvency professionals, and there is a self-regulatory organizations which regulate them. So you can see there are member of ICAI. There is an insolvency professional agency under ICAI, under ICSI, and ICMI, and 3 insolvency professional agencies house all these insolvency professionals. This statistics is quite interesting. You can see, so here still the female representation is less. So you can see there are only 378 female insolvency professionals, whereas there are 3,572. Now, I don't want to go into the details of it, but it is a good research question. Somebody can pick up and see that why this is the situation. Though this is the situation across the establishment, that we don't have a lot of women representation in places, particularly leadership. But I'm happy that to see Dr. Payal here in this particular position. We want more leaders into the positions of vice chancellors, directors, deans, directors, women directors. So I believe this needs to be taken an attention of, and maybe Insolvency Bankruptcy Board of India should put up some scheme or initiative wherein more and more women join the insolvency professional. Insolvency professional entity is also a very, very important agency. So this is basically what happens is insolvency professionals are in their individual capacity, liability as well as this, whereas insolvency professional entity is a group of people. It is just like LLP, it is like a firm of insolvency professionals called insolvency professional entity. So this is the first pillar and an important pillar, because the whole functioning of the Insolvency and Bankruptcy Board rests on this pillar. Second pillar, which is of information utility. This is another unique element which is there under Insolvency Bankruptcy Code. So I don't know whether you people are aware about the proceedings under winding up proceedings under the Companies Act. One of the major challenges which is brought before the courts is in relation to the default. So whenever a notice of default goes to the creditor, to the debtor first of all will object, I deny, or they will say, I dispute this particular amount, or I have a counterclaim. All these things will be brought up by the debtor on the creditor. This situation is a difficult situation. Then thereafter court interpretation, dates after dates after dates, and things will keep on lengthening to just prove default. Now that particular scenario has completely changed. Now there is an information utility which houses the information relating to all these loans, all these loan documents. And it is a third-party information center. As soon as you default, your information utility issues you a certificate of default. That certificate is a conclusive certificate, is a proof basically in front of the court that yes, the default has happened. So they don't examine the question of default thereafter. A lot of time gets saved. Now there is an integration of other databases also with the information utility. Presently, the one information utility which is registered with the IBBI is National E-Governance Securities Services Limited. So this is another important pillar under the Insolvency Bankruptcy Code, which is helping the process to go faster by providing the proof of default. Then comes the adjudicating authorities. As I told you, adjudicating authorities is now transformed. Previously, if you will look at the matters used to go to high courts. Different high courts would get company matters of liquidation and all those dimensions. Now here, the matter, there is a specialized tribunal constituted, that is National Company Law Tribunal, to whom all the matters relating to IBC goes, and they decided. There is a specified benches in different cities. If I'm not wrong, about 16 cities we are having now in NCLT, and in all these cities there are benches, and the composition of the bench is such that there is a judicial member and there are 2 technical members to assist the bench, and that is how the composition helps to look at the matter technically and faster. Matters from NCLT goes in appeal to National Company Law Appellate Tribunal, and from there to the Supreme Court. This is how this corporate insolvency regime is applied. Part 3, as I have already told you, is not yet into force. Once it comes into force, then all individual defaults, which is presently dealt with under the Provincial Insolvency Act, will be taken care of by the Debt Recovery Tribunal. So this adjudicating authority is doing a great job, and this is another pillar. The most important pillar is the Insolvency and Bankruptcy Board of India, because this is the pillar which basically takes care of the regulation of insolvency professionals, insolvency professional agencies, information utilities. All review of regulations which you are finding is being done by the regulator. They make regulations, and they do a lot of research and analysis. And I have referred to that in my first slide about IBBI newsletter. Please refer to the latest newsletter. It will give you the complete statistical data. They have progressed. I see a marked difference, a lot of progress happening on IBBI newsletter from the first newsletter till now. They are even giving the data in Excel along with it. So for researchers, I believe it is a boon, and you can review that, talk about it, write papers. That is something which is very much possible. And they are also evolving best practices. You will be surprised to know that IBBI has a regulation to make regulations. I believe I have never seen somewhere where there is a regulation to make regulations. It is quite interesting. Then corporate insolvency. What is corporate insolvency? You must have studied, winding up in your LLB. If you are an LLB, if you are a generalist, then also corporate insolvency. I have told you that if a company has taken a debt and there is a default on that particular debt, then the corporate insolvency resolution process starts. So if you have a look at, this is what is the slide which tells you about 3 different types of creditors. So who can bring the default before the company? There are 3 people who can bring the default from the company. But before I move further, I would like to ask any questions you have. You can put in the chat box, because I have not yet seen any question on the chat box. I'm just tracking the chat box, but I'm yet to get any questions. If there are questions, please put it in the chat box. Okay, I see some questions. Okay, wonderful. Okay, this is a quite interesting question. If someone took the loan in India and went to the foreign country, okay. So anybody who took the loan in India and went to the foreign company, now the government has come up with Fugitive Economic Offenders Act, and their asset in India is being auctioned. That is the task which is happening nowadays. So there is a separate legislation to take care of that. So that is happening. Okay, so there is a question on process. So let me talk about that briefly, and then we will move ahead with the question and answer. I will unshare the screen, and then we can talk. So you can see here there are three kinds of people who can bring the insolvency proceedings, corporate insolvency proceedings. One is the corporate debtor himself. So as you can see in this particular slide, we are having corporate debtors who can bring the slide. So this is commencement of liquidation, and here you can see there are financial creditors. So if you see, there are financial creditors who can bring the proceedings, and then there are operational creditors. So there is a differentiation between financial creditors and operational creditors. The jurisprudence is now quite settled. So financial creditors are creditors like banks and all. Operational creditors are creditors who lend the company on a day-to-day basis, like electricity company who is giving electricity to the company. If there is a default, it is an operational creditor. Financial creditor is maybe 1,000 crore rupees given them as a loan, is a financial creditor. Corporate debtor himself can also initiate corporate insolvency proceedings. If you see, this is the time. So what happens generally? Whenever there is a default, as soon as default happens, the applicant will make an application to the adjudicating authority. Adjudicating authority will then appoint an interim resolution professional. This interim resolution professional will take charge of the company immediately from the existing board, and everything will be taken away from the existing people. Why that is done? Because to take care of any unproportionate transactions or maybe extortionate transactions. So people should not take away the money from the company and then nothing is left out. That should not happen. IRP takes care of that. So they just freeze everything in their own hands, and operation of the company for next 30 days is with the IRP, that is interim resolution professional. Then there is a public announcement by the IRP. IRP invites all the creditors of the company that this particular company, X company, is under corporate insolvency resolution process now. And now if anybody has a debt against the company, please bring your proof, and a list of creditors is prepared, financial creditor as well as operational creditor. And then this constitutes then the verification is done by IRP, and a committee of creditors is constituted. After the committee of creditor is constituted, this committee of creditor information is filed to the adjudicating authorities, and adjudicating authority takes it in record, and on 30th day or before that, there is a meeting which happens of the committee of creditors. This is the time when committee of creditors takes charge of the company. The whole committee now thereafter decides what has to be done of the company. They call for resolution plan. Resolution plan is from the companies in the market. So any company which is going under CIRP, anyone can bid for it. Like for example, Ruchi Soya was taken by Patanjali. Similarly, there are many other companies wherein the resolution plan, by way of resolution plan, the company has been resolved or company has been uplifted. Somebody else takes over the management. So the essence or the basic principle behind it is that failure may happen. There are two kinds of failure. One is called economic failure, one is called financial failure, and the other one is called business failure. T.K. Viswanathan committee talks about these two kinds of failure. One is business failure and one is the financial failure. Whenever there is a financial failure, that can always be cured. So insolvency is basically nothing but financial failure. But if there is a business failure, the idea itself fails, nothing can be done in that case. So that failure is okay. But what has happened by way of insolvency bankruptcy code is that now we have started celebrating failure. Our culture in India, generally we don't celebrate failure. We always reprimand failure. We always have a culture of looking down upon the failure. I believe this needs to change, and probably there is a change which is happening, and failure needs to be celebrated, because once you fail, then you grow, then you move ahead, and that applies to everyone. And I believe insolvency bankruptcy code is something which is propagating this particular thought, propagating this particular idea that failure should be If you don't give this particular room to the enterprises to experiment, to the enterprises to fail, and there is a stigma of failure, nobody would like to experiment with new ideas. Nobody would like to experiment with new businesses. And it is important for the economy, for the country, that you allow that particular opportunity to young entrepreneurs, to the people who want to innovate, want to try new ideas, and there should not be a stigma associated with insolvency of failure. And this is exactly what is IBC doing, and that is the thought which is important. Now, if you see, these are some of the timeline, and I was talking about timelines, right? So 180 days to 270 days, you can find this is what is the period within which the resolution has happened. So 73% of the cases, these are the ongoing CIRPs, which is happening, and there are about 11% cases which has been resolved within 90 days. So if you look at this document, it shows that though IBC, as far as timeline is concerned, it has done, as far as recovery is concerned, it has done well. But on timelines, probably there is a requirement of a bit of a nudge, or a bit of a ramping up as far as the adjudicating authority is concerned and the processes are concerned. More number of tribunals are needed, more number of professionals are needed who can work in this area. So this is the latest data which you can see in IBBI newsletter October-December. I leave the interpretations to you. Liquidation timeline is also provided under the corporate insolvency regime. But if a company has to go for liquidation, no more liquidation happens under the Companies Act. Liquidation is also under IBC now. And there also the timeline has been provided, maximum 2 years. That is what it is. So if you will see, these are the more than 2 years, about 46% of the cases are taking more than 2 years. So here also the timelines are a bit, skewed. So what needs to be worked on insolvency regime in India is the timelines. So doing the thing on time. This has been a big cultural problem also, which we have been facing, that things which we prescribe, that yes, this thing will be done within this 2 years, needs to be done within 2 years. That is something which requires an attention as far as the insolvency is. This is a picture which is again coming from IBBI newsletter, and you can see here the modes of closure of CIRP. So corporate insolvency resolution process, 46% cases have been closed by liquidation. So this is quite a number. Ideally speaking, this should change towards approval of the resolution plan. So at present, there is only 14.7% cases which gets resolved or get the approval of the resolution plan. There are about some cases which are withdrawn also. So this may be the settlement which has happened, about 17.31 cases. And appeal and review, there are 21.99 cases which goes in appeal and review. Naturally, this is a new law, so this much of appeal is perfectly fine because jurisprudence is getting settled. So as you can see here in this particular slide, the 21.99% figure will go down slowly over the years. Objective should be that this 46.63% should move towards 14.07%. That is approval of resolution plan. So it is quite an interesting diagram which shows us that how this trajectory is moving as far as insolvency regime is concerned. These are some of the sectoral distribution of the corporate insolvency process. As you can see here, construction, about 11% of the insolvency matters are coming from construction, 40% coming from manufacturing, real estate about 20%. So construction and real estate, if you club it, about 31% coming from there. Others 11%, retail trade 10%, transport 3%, electricity 3%, and hotels 2%. This is what is the structure as far as the insolvency. As I told you before, there are a lot of statistics, a lot of data, and I leave it to you. I'm sure there will be a lot of PG students here in this session. From PGDT, we have a great tradition of doing a lot of research. I'm sure you will be taking forward some of these points into your research areas and doing your dissertation in these areas, and definitely that is going to contribute. We also write some critique on the judicial decisions which have been given. In today's today's presentation, I have not covered any judicial decision as such, except Swiss Ribbons, which is a landmark decision of Supreme Court. There are plenty of decisions which have been given by Supreme Court. There can be a lot of analysis around that as well. So if you see, this is the famous 12, accounts which went under liquidation as soon as IBC was announced, and you can see the whooping amount which has been received as per the liquidation value. So 387% of the liquidation value has been received. This is quite a success in these cases. So as far as recovery amount is concerned, whatever has been resolved, I'm talking about these 14.7%. The amount recovered is quite good. So this is very, very interesting data and interesting dimension which is being presented. So that's it. I thank you, all of you, for giving me this opportunity to speak. Now I am open to questions. I will just unshare the slide so that I can read your questions and answer them. Yeah. Okay, liquidation process under the IBC and Companies Act no more exists separately. So there is only one liquidation process under IBC now, and that is what has to be followed. The difference, as I told you before, is in terms of process. Now the process under the IBC is pretty settled, and there is a resolution professional which is there who helps in resolving the voluntary liquidation as well. And how can we rate the efficiency of IBC over Companies Act 2013? I leave it to you. You just look at the statistics, how the statistics have changed. Previously, the corporate insolvency average age was 8 years. Now we saw that maximum is 270 days, right? So I believe that itself shows that how fast it has gone. Saurabh has a question. It says, parallel proceeding under SARFAESI Act, can we file an application for insolvency under this code? Not within the moratorium periods. If SARFAESI is there, then still you can file under IBC. But if you have filed an IBC, then you cannot go under SARFAESI till the moratorium period is there. So moratorium period is one has to exclude. I think it is 180 days. Okay, I have asked SARFAESI. BIFR is no more in existence, Surendra. So BIFR has been wound up, and BIFR was not a very successful agency. VP Singh at one point in time said that it is a failure. I've covered that in my article. You can have a look at it. Pratibha Gupta asks a question about cross-border insolvency. Okay. Yeah, this is a myth, Pratibha. When we say it resulted in failure to bring back the hardest earned money citizens in Vijay Mallya, we have already recovered a lot of money from Vijay Mallya, and there is only it is on principle we are talking now that he should surrender to the law of the land, and if there is a punishment which he has to be undergone, then he should. So that is the discussion which is happening. As far as the amount is concerned, I believe a lot of amount has already been brought up if you are tracking this particular case. And further, now we have a legislation called Fugitive Economic Offenders Act, and that is taking care of this recovery part of the people who fly away from the country. Difference between bankruptcy and insolvency. Generally, there is no difference. These are the terms which we use colloquially as the same. But if one has to make a difference, bankruptcy refers to individual and insolvency refers to corporate. But this is not. This is just a colloquial difference. Otherwise, it is same. When a person or firm becomes insolvent, what are the proceedings for insolvency? Okay, this I have already answered, Shoaib. That's great. I think I have answered all the questions. So wonderful. Any more questions you can ask if
Sir,
they have a permission to ask?
Sir,
yeah.
Sir, I want to ask one question, sir.
Yeah, please go ahead, Padma.
Yes, sir. Sir, in Videocon case, sir, the COC is the highest authority, we can say, or in Videocon case, sir, the COC approved and submitted the resolution plan with 96% haircut, sir. And the CLT approved this plan. I agree, sir. CLAT squashed this decision of NCLT. But, sir, my question is that, sir, we do not have Sir, whether the power of approval is not including the power of rejection, because the NCLT held that we do not have power of rejection. And when the COC submitted the plan, the NCLT has to approve this plan. So my question is regarding the NCLT, the power of approval is not included the power of rejection.
No, power of approval includes power of rejection, Padma.
Rejection,
So
yes,
in
yes,
this
sir.
particular case, if you look at the Supreme Court decision, Supreme Court is very clear on this, that COC is the wholesale master as far as
Yes,
the
yes, yes, sir.
resolution plan is concerned. So they cannot sit on the business judgment of the resolution plan. However, if you see that if a party brings an unfairness action or brings something which is fishy as far as approval of resolution plan or process not being followed, then in that particular situation, the National Company Law Tribunal can look at it only on the grounds of legality and the principle of justice, but not on the sound judgment that whether resolution plan is right or wrong. So that is what exactly has been held. And definitely it includes rejection of the resolution plan. But ultimately, if you will look at it, what is the objective of COC? Is not rejection of resolution plan. Objective of COC is acceptance of resolution plan. So if there are four resolution plan which has been received by them, now say for example there are two companies which are giving resolution plan to the COC. One is giving a haircut of 50%, the other one is giving a haircut of 60%, and COC chooses the 50% one. Then naturally there is a question that why they are taking a hit of 10% thing. That can always be challenged. You're getting my point. So here basically principally, if you will look at it from a jurisprudence point of view, National Company Law Tribunal has a limited jurisdiction as far as resolution plan is concerned. They cannot go into the details of the business justification of the resolution plan. That they cannot do.
Okay, sir. Thank you. And sir, but when they are accepting the 96%, when they are approving this particular plan, can we say that they are killing the main objective of IBC, which is the maximization of asset of the company?
Yeah. So, but if say for example they don't do that, they lose 100%, right? So it is better to have at least something by 95% haircut than 99% haircut.
Okay.
So we cannot sit on the judgment, no, Padma. So that is what is happening here right now, is that we as common man, we have everybody is talking about, nowadays on WhatsApp University, the trend is that government is selling everything or killing everything. And I recollect Dr. Payal teaching us disinvestment in the class, and we had a discussion, right? Disinvestment long back. You recollect when I did my LLM, we were talking about disinvestment, and there was I still recollect my presentation of disinvestment, and we are here square one, and we are talking about that. So why you want an enterprise? These are all political statements, and statement which is to fan a public on a particular issue is different. But when you are examining it from a legal perspective, from a perspective of an economic angle, the questions are quite different. So these are these I always tell my students, you need to differentiate between these two dimensions very, very clearly. You as a researcher have to be neutral. You have to see from both the lenses that why COC is approving 95%. अब COC को अगर कोई 50% haircut पे दे रहा है तो वो क्यों नहीं अप्रूव करेंगे, लेकिन उनको नहीं मिल रहा है. So they are happy, at least something is better than nothing.
Sir, and I want your opinion on the COC's due diligence, sir. Because
yes, COC does the due diligence. COC has to do the due diligence because their objective, because there is only one person in the COC. There are a group of people who are there in COC, right? All the creditors have to take care of that. And there is if there is a conflict of interest between any of the COC members, that has to be flagged. These are the mechanisms which are very much mentioned, and that is why there is a neutral party also. What is the role of insolvency professional? Insolvency professional has to ensure that all these things are met properly. So COC is not completely free hand. There is always an insolvency professional in the middle who is bound by the oath or his processes. There is a regulator which is regulating them. So they have to take care of that.
Thank you, sir. Sir, as a researcher, I have many questions in my mind. So if you permit me, I will ask you later in person, sir.
Definitely. It seems you are doing your research on insolvency.
Yes, sir. Yes, sir. Yes, sir. Yes, sir.
Yeah, I can understand that. Okay. Anybody else has any question?
Thank you, sir. I think there is no any more questions. So it is then end of question and answer session. Thank you, sir, for giving your insightful knowledge over the topic. And now I request to Mrs. Padma Chobe, ma'am, to deliver formal vote of thanks.
So, good afternoon, everyone. It has been such an honor to be a part of this wonderful session. So, on behalf of Postgraduate Teaching Department of Law, Rashtrasanta Tukadoji Maharaj, Nagpur University, Nagpur, I would like to extend my heartfelt gratitude to our esteemed guest, Professor Dr. Vijay Kumar Singh, sir, to spare his precious time from his hectic, busy schedule to enlighten us on the continuous evolving nature of the topic, that is insolvency and bankruptcy code. Sir is very well explained about the opportunity of free exit mechanism, then the objectives of the code and the necessity and need of the code, and many more information which sir given us. Then I thank Dr. Payal Thore, Madam, Head of the Department, Postgraduate Teaching Department of Law, Rashtrasanta Tukadoji Maharaj, Nagpur University, for always being a pillar of strength, better, and supporting and guiding us to take a scale in new horizons. I would like to thank Ms. Shivani Khandate, Madam, who has poured in a lot of efforts and hard work for making the event successful. I would like to thank Mr. Abid Khan, sir, who has been always there to take care of technical aspect of the each and every program. Last but not least, I would like to thank the organizing team, volunteers, and participants for working hard for the past few days to make this webinar successful. Thank you, sir. Once again, I want to thank you for accepting our invitation and enlighten us.
Thank you. Thank you. It was always a pleasure of mine, and I feel very happy to be here. And I'm also impressed by the way you people have done this, because our university is a traditional university, and the kind of coordination which is required, I completely understand because I have been part of it. But still, I am quite impressed by the way you have done this work. Thank you.
Thank you, Vijay. Thank you so much. I would also like to tell you this is our webinar series which is going on. Today was our 8th national webinar we conducted. So
Wonderful.
thank you so much. Thank you for being a
Thank
part
you.
of
Thank you, all of you. Have a nice day. Bye-bye.
Thank you, sir. Bye, sir.